Friend, Chairman of the Intelligence Committee, Mr. Turner, for any opening statement he cares to make.
Mr. Chairman, thank you for having us. We're very pleased to be here with what is an excellent reform bill. Mr. McGovern raised the question as to why are we so late. This is the Section 702 of the Foreign Surveillance Act expired December 31st, but we've had this period of time where we have had to have serious review of the intelligence community's failures and their abuses of some of the most critical tools that we give them to keep our nation safe. No question, we are here, as Mr. McGovern asked, because the intelligence community failed us. The FBI failed us, the intelligence community failed to properly police themselves, and they abused the tools that we gave them under FISA. There were searches of Americans' identities in the 702 database that should never have occurred. And there was a presidential candidate, ultimately President of the United States, President Trump, who had his own campaign team brought before the FISA court and actual warrants, probable cause warrants, issued in the FISA court in what was the most egregious defrauding of a court system that we have had in our political system, where they went to the court and entered in what was basically political opposition research that had been paid for by the Hillary Clinton campaign and the Democratic National Committee to obtain warrants to surveil an individual who was associated with the Donald Trump campaign. We are here only this late because we've had to struggle with these abuses. These are not abuses of Congress. In fact, Congress is the one that ferreted these out. By law and statute, we required that the intelligence community report to us their uses of FISA and their searches of U.S. persons within the 702 database, and those abuses are the ones that we, the Intelligence Committee, pulled together a joint group between the Judiciary Committee and the Intelligence Committee to be able to identify real reforms. This bill, the underlying bill, provides 55 reforms both to the FISA court process, to the FBI's processes, and to the use and the collection of 702 data that go right to the heart of the actual abuses. They're not stabs into the dark, they are actual definitional responses to each of the abuses that we found. Now, the Chair and Ranking Member of the Judiciary Committee unfortunately want to debate an amendment that's coming up rather than the solutions that we provided, and I want to first focus on those solutions. Together, the Judiciary Committee and the Intelligence Committee came up with 55 recommendations that reform the FBI querying process, basically taking it out of the hands of the rank and file of the FBI. We found that their abuses were so egregious that the FBI was broken and we had no ability to continue to trust the system. So we elevated and limited their use of 702 FISA information. We made certain that the FISA court itself could not ever again be subject to the political abuses that occurred in the Trump campaign. And in all of these, we went back and made criminal penalties for anyone who violates these new higher standards. We also gave specifically an opportunity for Congress in its oversight to increase its oversight of these so that we can ensure that the criminal prosecutions occur for those who might violate these provisions in the future. Now, the Chair and Ranking of Judiciary are talking about imposing a warrant on the search of 702 information. And I want to make a few things clear. There is no warrantless searches of American citizens' data. That does not occur under FISA. It's not permissible under FISA. It's illegal. They don't even have the mechanism within which to do it. They survey foreigners located abroad and a limited subset. It's about 250,000 people. It is subject to court supervision, and the court supervision is determining that each of those individuals represents a national security threat, a foreigner abroad, national security threat to the United States. So what would their warrant requirement be then? If it's foreigners that are abroad, what would their requirement be? It would be to go in to the head of ISIS, to go into the head of Hamas's data, and look in that data that where Americans' names and American citizens who are communicating with Hamas and ISIS may be. It's not going into Americans' data. There is no warrantless spying on Americans under 702 or FISA. There is no ability to go into American data under this law except with a warrant. There already under the law is a requirement that if you're going to go into Americans' data, that you must get a warrant. The requirement that they're asking for is a warrant if you go into Hamas's data and look at Americans that are corresponding with Hamas, or if you go into ISIS data and look at ISIS data for Americans that are corresponding with ISIS. Now, first off, there is no constitutional requirement for that. The courts have already ruled that you have no constitutional right to privacy as an American to correspond with an ISIS head who's a foreigner located abroad. That is not protected communication. Now, your communications remain protected. We can't go into your communication, into your data without a warrant. But if you communicate with ISIS, the head of ISIS, or the head of Hamas, you lose your constitutional protection under those communications. If we're spying on the head of Hamas, which you and Americans would want us to do, your communications are going to be caught up at the head of Hamas. To impose a warrant requirement is dangerous for America. The Wall Street Journal stated, Section 702 lets the government monitor non-U.S. citizens outside the United States to protect national security. Don't let anybody tell you this is a warrantless program surveying Americans. The House Judiciary Committee has gone the wrong way. The legislation that could end Section 702 would make it useless as a national security tool. The bill would require their amendment, a warrant for queries of U.S. persons, even though the information is already collected. In other words, what the Wall Street Journal is indicating is if you collect Hamas's data, you shouldn't need a warrant to look at Hamas's data, even if an American is in there. If an American is communicating with Hamas, it's a national security threat. We should not have a warrant. It will shut down our ability to be effective. I yield back.
Thank you very much.